Sale of real property, aka land conveyances or sale of real estate. Normally, the sale of personal property is a quick and simple transaction. However, real property, aka real estate or land, presents a slightly more complicated transaction. There are two steps in the sale of real property: the contract and the deed. The contract is the controlling document until the closing of the sale, when the buyer makes payment in exchange for the seller's deed, which becomes the controlling document. These two steps change the way we refer to the parties involved. When the contract is the controlling document, we refer to the parties as the seller and the buyer, because contract law is involved. When the deed becomes the controlling document, the seller becomes the grantor and the buyer becomes the grantee, because property law is involved. Thus, this is why we interchangeably use seller/buyer and grantor/grantee, depending on where we are in the transaction. The contract. The contract is temporary and expires at the closing of the sale. The contract must be in writing to satisfy the statute of frauds. However, it does not have to be in writing if the buyer takes possession and pays at least part of the purchase price or makes substantial improvements to the property. This is called the doctrine of part performance. While normally a contract is signed by both parties, the only required signature is the signature of the party who will be potentially sued, i.e. the future defendant. The contract must describe the property and state the price, i.e. the consideration. Note, if the amount of land ends up being less than the amount described in the contract, then the contract is still honored, but instead the price is reduced proportionally. This means that the seller is held to specific performance, i.e. the seller must still transfer the land. The common law has a doctrine called caveat emptor, which means buyer beware. Thus it is not a surprise that there are no implied warranties of fitness or habitability. The one exception is for the sale of a new home. The new home comes with an implied warranty of fitness and workmanlike construction. However, today there are two implied warranties in every real property contract: marketable title and duty to disclose, i.e. no false statements. Marketable title is the seller's promise to provide property that is free from reasonable doubt at closing. This means that at the time of closing, the property does not have any current or future threat of litigation. Examples of when the property does not have marketable title are: if any part of the property is affected by adverse possession, the property is not marketable. If the property has any encumbrances, the property is not marketable. An encumbrance is a right, interest, or legal liability on real property that diminishes its value. Some examples of encumbrances are servitudes and mortgages. If the property is in violation of a zoning ordinance, the property is not marketable. Duty to disclose. The seller promises not to make any false statements of material fact. In addition, the majority of states require the seller to disclose known latent material defects. This means that even if the buyer conducts a reasonable inspection before the sale and the defect develops later after the sale, the seller is liable for his material omissions. Note, the implied promise against false statements cannot be defeated by a general disclaimer of liability, i.e. sold as is, or with all faults. One scenario that the bar frequently tests on is when there is destruction to the property sometime after the contract is signed and before the closing of the sale. Once the contract is signed, the buyer is responsible for the land. This includes the risk of any loss. The reasoning behind this is based on the doctrine of equitable conversion, which states, equity sees that as done what ought to be done. In simple words, this means that, out of fairness, something that will truly be completed in the future is treated as having already been completed. For review, please see the video lecture on concurrent estates at 7 minutes. Since it is physically impossible to transfer real property by hand, a written instrument which represents ownership is used instead. Thus, all transfers of real property, whether it is by gift or sale or some other form, must be accomplished by the transfer of a written instrument that represents ownership of the property. This written instrument is known as the deed. Although the buyer already owned equitable title to the property when the contract was created, as we just learned in discussing the doctrine of equitable conversion, the buyer obtains ownership of legal title when the deed is transferred. Legal title requires that the deed be executed and delivered. Execution of a deed requires written form because of the statute of frauds, the granting clause. This is a statement which indicates that the grantor is transferring property to the grantee. Note, the actual names of the grantor and grantee do not have to be specified, so long as there is no doubt as to who the grantor and grantee are. description of the property, any other statutory requirement, and the signature of the grantor. The granting clause usually states the consideration, i.e. the buyer's payment, but it is not required for a deed to be executed. However, consideration must be included if the buyer wants to prove that he was a bona fide purchaser. Being a bona fide purchaser is necessary to gain protection from future repossession by an adverse party. Note, bona fide purchasers and the risk of repossession is discussed in detail later in a subsequent lecture on the recording system. Delivery. While the typical delivery is made by a physical transfer, it does not have to be. Delivery is decided based on the intent of the grantor. So long as the grantor's intent is to be immediately bound by the transfer, then there is a delivery. There are three types of deeds: the Quitclaim Deed, the General Warranty Deed, and the Special Warranty Deed. Before we get into the details of each deed, it is helpful to give you the basic idea of how these three deeds compare. The Quitclaim Deed does not have any protection, the General Warranty Deed has full protection, and the Special Warranty Deed has some protection. The Quitclaim Deed is the worst deed to have because the grantor does not promise anything. Thus, there is no protection. The grantor may not even own the property in the first place. The General Warranty Deed is the best deed to have. It protects against all defects of the property. This includes defects during the grantor's ownership and before. The General Warranty Deed has 6 covenants, which are promises on behalf of the grantor and the past owners. Covenant of Seisin. Grantor promises that he owns the property that he is conveying. Covenant of Right to Convey. Grantor promises that he has the right to convey the property. Covenant of No Encumbrances. Grantor promises that there are no encumbrances on the property. An encumbrance is a right, interest, or legal liability on real property that diminishes its value. Some examples of encumbrances are servitudes, mortgages, and liens. Covenant of Warranty. Grantor promises to defend against third parties' lawful claims of superior title and promises to compensate for any loss. Covenant of Quiet Enjoyment. Grantor promises that grantee will not be disturbed by a third party's lawful claim of superior title. This covenant is practically identical to the Covenant of Warranty and is often not included in general warranty deeds. Covenant of Further Assurances. Grantor promises to take any other action that is necessary to ensure a perfect title, i.e. a marketable title. These covenants are easy to remember because of our friend named Señor Week, who embodies the covenants of the General Warranty Deed. Señor Week promises that he owns the property that he is conveying. Señor Week promises that he has the right to convey the property. Señor Week promises that there are no encumbrances on the property. Señor Week promises to defend against a third party's lawful claims of superior title and promises to compensate for any loss. Señor Week promises that grantee will not be disturbed by a third party's lawful claim of superior title. Señor Week promises to take any other action that is necessary to ensure a perfect title, i.e. a marketable title. This means the property will not be threatened by litigation. You probably have now noticed that the first 3 covenants are phrased in the present tense, and the last 3 covenants are phrased in the future tense, and thus the covenants are split into 2 groups called present covenants and future covenants. The 3 present covenants can only be breached when the deed is delivered. This means that the statute of limitations for breaching a present covenant begins at the instant of delivery. The 3 future covenants can only be breached when the grantee is disturbed in possession. This means that the statute of limitations for breaching a future covenant begins at a future date. The Special Warranty Deed has the same covenants as the General Warranty Deed, but it is different in that it only protects against defects of the property which are associated with the grantor's ownership of the property. Thus, it does not protect against defects from before the grantor's ownership. For review, here are the basics in a sale of real property. A seller and a buyer sign a contract for the sale of real property. While usually a contract for the sale of personal property is quick and simple, in the sale of real property the contract is only the first step. The contract designates some date in the future when the buyer will exchange his payment for the seller's deed, i.e. ownership of the property. This is called the closing of the sale, or just closing for short. The time allotted before the closing allows the seller and the buyer to conduct research to assure that there are no unknown issues. For example, the seller doesn't own the land. The contract is the controlling document until the closing. At closing, several things happen. As we already said, the buyer exchanges his payment for the seller's deed. This is the part of the transaction where we shift from contract law to property law. Thus, we no longer refer to the parties as the seller and the buyer. Instead, the parties involved are the grantor and the grantee. As part of the grantee's new ownership of the deed, he now has legal title, as opposed to only equitable title, which he had when the contract was created. Remember that legal title requires the deed to be executed and delivered. Once the exchange is completed, the contract is also completed, and thus the deed becomes the controlling document. Finally, there are three types of deeds: the quitclaim deed, the general warranty deed, and the special warranty deed. The last bit to know about the sale of real property is that real property is usually sold with the use of a broker. A seller hires a broker to help find a buyer to purchase his property. In exchange for finding a buyer, the seller pays the broker a commission, which is usually a percentage of the purchase price. In the contract between the broker and the seller, brokers will often include that the broker is entitled to commission even if the seller finds a buyer from a source unrelated to the broker. Otherwise, a seller could take advantage of the broker's marketing. When a broker completes their job, but the deal fails for some reason which is unrelated to the broker, at common law, the broker was entitled to the commission as soon as the seller was presented with a buyer who was ready, willing, and able to buy the property for the price asked for by the seller. The broker would still be paid a commission even if the buyer ended up breaching the contract and not buying the house. The modern trend entitles the broker to the commission only when the buyer pays the purchase price. However, if the seller breaches the contract and the deal fails, all jurisdictions entitle the broker to the commission.